Good afternoon. Welcome and thank you for joining us for this month's Health Law webinar, where the topic is immigration. Prior to starting our talk, a few housekeeping tips. You may use the chat function at the bottom of the screen to send specific questions. We'll try to save time at the end to answer them. Otherwise, please provide your contact information and we will follow up privately. Should the internet audio cut out, please use the dial-in number provided. Today, Deborah Schneider and Jenny Mojica will talk to you about the topic of immigration and healthcare workers. As the demand for workers grow, more employers are turning to sponsorship of highly skilled foreign nationals to meet their hiring needs. As such, today we'll be discussing how best to sponsor workers and add them to your workforce.
So it might be a surprise to some, but probably not many attending this webinar, that foreign healthcare workers are really vital to this country's ability to provide comprehensive medical treatment and care to its residents. But how do you know if somebody is a foreign worker requiring visa sponsorship? Oftentimes, the individual proactively make his or her immigration status and needs known by bringing up sponsorship issues during hiring discussions, for example. But other times it's not entirely clear whether or not somebody requires sponsorship. After the passage of the Immigration Reform and Controls Act, or IRCA, in the mid-1980s, it became unlawful to discriminate on the basis of actual or perceived national origin, citizenship, or immigration status during the hiring process, or to ask for specific documents evidencing someone's work authorization. So asking someone where they are from or for a copy of their green card during interviews or their hiring process is clearly prohibited. In fact, there are only two permissible questions that an employer can ask to understand a candidate's sponsorship needs, and those are you presently legally authorized to work for any U.S. employer? And will you now or in the future require visa sponsorship? To avoid any claims of national origin, citizenship, or immigration discrimination, these questions really should be asked of all candidates for hire during the pre-screen or interview process. Turning now to our discussion about physicians specifically, let's say a physician candidate discloses she requires sponsorship. Oftentimes, foreign medical graduates are here in a residency or fellowship program in J1 visa status. And typically, J1 visas will run approximately from June 30th to June 30th to coincide with the dates and duration of medical residencies or fellowship programs. J1s are typically admitted for the duration of their program, plus a 30-day grace period, which grace period effectively tolls their ability to remain in the United States through the end of about July, but does not allow them to work. The trick with foreign physicians who enter on a J1 visa is that they're subject to what is called a 2-year foreign residency requirement that requires them to depart at the end of their program and provide services in their home country for at least 2 years before they're eligible to come back to the United States in another non-immigrant status or as a permanent resident. J1s are also not allowed to simply change status to H1B, TN, or other non-immigrant status, or adjust their status to permanent residence at the end of their J1 program. The exception to that rule is that if they apply for a waiver of the 2-year foreign residency requirement, which Deborah is going to talk about in a little bit more detail next, the J1 waiver process is lengthy and multi-layered and not one that can be taken care of in the final quarter of a candidate's fellowship or residency. Really, ideally, it needs to be started about 1 year out from the individual's J1 program end date to give the individual enough time to get through all the steps. So now Deborah's going to talk about the different waiver options and some strategies for pursuing the same.
So if you have a physician that you're interested in hiring, and they're obviously subject to 212E if they were on a J1, there are some options in how to waive that 2-year residence requirement. The first is the Conrad 30 program, which was established by Congress as a means to address the shortage of qualified doctors in medically underserved areas. Each state runs its own program, but must comport with the federal rules that govern the program, as the Department of State and the Immigration Service must ultimately approve the waiver. As I'll explain in the next slide in more detail, the Conrad 30 program has its limitations, as the waiver can be applied for only by facilities that are located in health professional shortage areas, medically underserved areas, or medically underserved populations, or if they serve a significant patient population that reside in these areas and qualify for a flex waiver. Depending on your state, the waiver slots can be highly competitive. Independent of an employer, the international medical graduate may have personal circumstances that may qualify him or her for a waiver of the 2-year rule. For example, by showing extreme hardship to U.S. citizen or lawful permanent resident spouse or child. What qualifies as extreme hardship is a discretionary determination by both the Department of State and the Immigration Service. It normally must rise higher than mere separation from a spouse or child, as the government presumes that separation was already anticipated upon marriage and accepting the J-1 program. Successful cases can include instances where there's health issues of the spouse or child. They may impose discrimination if they return to their home country, lack of employment opportunities in their field, learning disabilities of children, family planning issues, and significant ties to the United States. There's also a waiver based on persecution, or separately, the doctor could file for asylum. The persecution waiver means that the international medical graduate believes that he or she will be subject to persecution on account of race, religion, or political opinion. The persecution ground is much narrower than the ground for asylum, which provides additional categories of nationality or particular social group if one fears persecution. Unlike asylum, however, it does not have a requirement that the waiver be filed within 1 year of entry into the United States. Asylum and persecution waivers have become more frequent due to ongoing civil strife in many regions of the country. Finally, government agency waivers are sponsored by the agency themselves. For example, the Veterans Affairs, Health and Human Services, the Appalachian Regional Commission, and Delta Authority each have their own authority to grant waivers to physicians. An HHS waiver for clinical care, for example, can work well for facilities located in the HPSA with a score of 7 or higher, and a physician providing primary care or general psychiatry. Most health institutions are going to look initially at the state Conrad 30 waivers. Just as it said, this is the bedrock of waivers for physicians for both primary care and specialists. Every state gets 30 waivers regardless of its size or need, and each state has broad discretion in running their program and determining how the waivers are granted. The overarching theme for most states is proving the benefit of bringing this position into the community to meet the medical shortage. The key is to support the state's interest in securing physicians who are willing to commit to provide clinical care full-time for 3 years in the HPSA or MUA to meet the medical unmet needs of the state. Because there's 50 state-run programs, there's 50 different state programs. Each is unique in how it evaluates waivers, accepts waivers, and processes waivers. This can even change based upon the administrator in charge from year to year. Fortunately for you, I'm not going to go into each state's requirements, but I'll discuss the most common elements. First, you have to be located in a HPSA or MUA. Indeed, some states only allow HPSA-based facilities, as these are updated more frequently than MUA and MUP designations. However, if your hospital or clinic is not in a HPSA or MUA, many states provide up to 10 flex waivers to show that a significant patient population reside in medically underserved communities, and therefore the needs of the state are still met. Each state provides its own definition of what's the appropriate percentage of patients that reside in federally designated underserved areas. Second, you need to show that you couldn't find a U.S. physician. In a flex or standard Conrad waiver, you must show that you've conducted recruitment for physicians and were unsuccessful in recruiting U.S. workers. You're also, again, still going to focus on how this physician will meet the unmet needs of the community or state. There's often a bias in many states to grant physicians to rural areas. Is your physician working in a primary care or as a specialist? Minnesota, for example, supports both primary care and specialists, and in fact, some states issue more waivers for specialists than primary care. Others, however, accept primary care waivers first, and only if those slots aren't filled do they open for specialists. In either case, you must show the shortage for that specialization and why it's needed in the state. Fourth, you're going to have a 3-year contract, 40 hours a week, providing clinical care. 5, many states are also imposing an additional requirement that the facility has a sliding fee scale or a charitable care policy, accepts Medicaid, and agrees that the physician will serve the medically indigent population. Another factor is the timing. When do you file? It's important to learn when the state will first accept waiver applications, as each state sets its own policy for dates of submission, how it will accept cases, what it needs to look like in the package, and what weight will be given to early submissions. Additionally, you're going to need to look at your retention plans for this physician. What does the facility plan to do to retain the doctor after this 3-year period? And does it have a successful track record of doing so? A report from a few years ago showed that nearly half the physicians that had been sponsored under the Conrad program remained longer than the 3-year period. And finally, success. A successful petition is not about the needs of your clinic or even the expertise of the doctor, but it's about how adding this doctor to your town, region, and state will fulfill an important unmet medical need. All right, so you've gotten your waiver. Then what? First of all, it goes through a 3-step process. The state will first need to recommend the waiver. This could be as quick as a week in some or 3 months in others. Again, it's going to depend on the state. Once the state sends its recommendation, it will be forwarded to the Department of State, who will take another, often month to 3 months, to issue its own recommendation. Finally, it will be sent to the Immigration Service, who makes the final waiver decision. Then there must be an H1B filed for the physician to fulfill its ability to actually begin working for a full 3 years. As previously mentioned, the physician must still be in status within the U.S. to change to H1B status. If they run out of their J1 time, they must consular process at the U.S. Embassy abroad only after the H1B is approved. Jenny, what happens if you can't get a waiver?
Well, unfortunately, there are limited options for physicians who are subject to the 2-year foreign residency requirement, but who, for whatever reason, are unable to get a waiver. One of those options is to pursue an H1B visa status, demonstrating that the physician is an individual of extraordinary ability. The H1 is the only non-immigrant visa category that a J1 physician can pursue without the need to first get a waiver. There are a couple things to note, however, about this H1 option. First, J1 physicians applying for an H1 cannot change their status in the United States from J1 to H1 without a waiver. Instead, they must file a petition with USCIS, and once it is approved, they must process for an H1 visa at a consulate or embassy abroad. This then requires the physician to depart the United States. And it's only upon their readmission into the United States pursuant to their H1 visa that they're able to acquire and start working in H1 status. Another thing to note is that this option doesn't erase the foreign residency requirement. It rather just tables it as long as the person is in H1 status. So, for example, if the person decides he wants to pursue permanent residency from H1 status, he will not be able to just adjust his status to permanent residency in the United States unless he fulfills a 2-year foreign residency requirement or obtains a waiver first. And then critically, the H1 can be kind of tough to obtain. You've got to show that the person has received sustained national or international acclaim in his or her field of endeavor by presenting the government with evidence of national or international awards, scholarly publications, original contributions to his or her field, that he or she has judged the work of others, has played a critical role at distinguished organizations, and has received remuneration higher than that normally encountered in his or her field, etc. Basically, you have to show that the person is operating at the top of his or her field of endeavor when compared to his or her peers. The other option, apart from the H1, is to simply depart, do your 2-year term in your home country prior to re-entering the United States. At that point, you can come back as an H1B, a TN, a permanent resident, or otherwise, and once you're in the United States, you can move between visa categories without the need to depart per se. An important cautionary note, however, is if a physician reacquires J1 or J2 status at some point again in the future, they risk becoming subject to the 2-year foreign residency requirement a second time. But let's say for the sake of discussion that someone does get a waiver. Deborah, would the H1B be a common next step in the foreign physician's immigration process?
You betcha. Okay, so I'll talk a little bit about the H1B visa category. And first I'm going to talk about the CAP exemption. As we will be discussing our reference, as many of you may know, there is what's called an H1B lottery, which takes place on April 1st. So we are kind of a little crazy right now and working through those. But what that means is the government allows 65,000 plus an additional 20,000 for U.S. master's degree or higher holders to apply for one of these elusive H1B visas. And we call it a lottery because more employers file for these visas than are available by the government. And so you will race to the finish to file your petition on April 1, and then hope that you were successful in the random computer lottery to have your case actually adjudicated. So being a CAP exempt organization is a huge benefit because you don't have to enter this lottery. You're not at risk of making an offer of employment to a healthcare professional and finding out you don't get to employ them. So I think the key for most organizations is to figure out, can you be considered CAP exempt? In January of 2017, there was a high-skilled worker rule came into play, which were finally, after about, I'd say 20 years, codified what CAP exemption means under the regulations. Previously, most employers had been reliant on past approval for CAP exemption in order to secure future H1B CAP exempt filings, and that went away after the passage of the high-skilled worker rule. What it did, however, is laid out a very solid, I think, definition of what it requires. So first of all, it defined what is an institute of higher education, which is basically they're going to follow the federal definition as listed under 101A of the Higher Education Act. They then defined what is a related or affiliated nonprofit entity. So this includes the following. If you're a nonprofit that you're connected or associated with an institute of higher education through shared ownership or control by the same board or association, that's a pretty clear definition of a CAP exempt because you're that closely related to the university. Or the nonprofit is operated by the Institute of Higher Education. You'd have to establish that the university has control to operate the nonprofit. Or the nonprofit is attached to the Institute of Higher Education as a member, branch, cooperative, or subsidiary, again, shared ownership relationship. And this fourth category is the most often used because it's the broadest exemption. Or the key is that you as a nonprofit have entered into a formal written affiliation agreement with an institution of higher education that establishes an active working relationship with the university for the purposes of research or education. And here's the new provision that was entered. You also have to show that a fundamental activity of the nonprofit is to directly contribute to research or education mission of the Institute of Higher Education. So in less boring regulatory terms, what this means is you need to have a written contract that shows your agreement with the university. So for example, if you're a nonprofit clinic and you have foreign medical graduates do rotations through their residency and you have contracts for that with a university, that could be enough to put you into this CAP exempt category. And this does not mean you're only CAP exempt for those physicians under that program. This means any worker coming in. So this could be nurses, this could be healthcare professionals, this could even be IT individuals coming in could qualify under this CAP exemption. So this is an important exemption. When it first came into play at passing the rules, I will say immigration issued a substantial amount of requests for evidence because they were themselves trying to work through what was the qualifying documents they wanted to see. But since then, we've had fairly smooth sailing. I am knocking on wood. And what that means is we've included the formal copy of the affiliation. We've included, where possible, a letter from the university confirming that it agrees that one of the fundamental purposes of the relationship is to contribute to research or education. And I think in the medical field, it's fairly easy to prove because anyone who's attempting to educate physicians through rotations at their clinic or their hospital is meeting this category. So that's something to try to examine first if you do need to sponsor for a national in the H1B visa category. For your Conrad Waiver physicians, they themselves are exempt. So it's not the institution or the facility that they're working at, but by virtue of regulation, the physician itself is CAP exempt, which is fortunate because it would make the Conrad program impossible to use if you had to wait for an April 1 lottery. So once you get the waiver, and really often it's once you get the recommendation from the State Department, you can file your H1B petition. What's also interesting is that it's not just for your initial H1B under the Conrad waiver. Following those 3 years, the physician themselves remains CAP exempt, which means even if they transfer to another employer, even one that's for profit, they are CAP exempt, and an H1B for them can be filed at any time. There's also cap exempt, I'm calling it the H1B portable physician, but really it could be any healthcare professional or any other H1B worker. Once an individual has been counted in the H1B lottery, they're within the 6 years, they're always counted. So they can port, meaning they can take their H1B, having been counted in the lottery, to another employer and begin working upon the filing of the application if they qualify under the portability physicians.
So let's go back just for a moment to talk about the H1B cap and timing considerations surrounding that. If you're lucky enough to be selected in the lottery and then approved, the earliest one of these petitions will go into effect is October 1. The October 1 effective date of the H1B can present problems for foreign physicians who are completing their J1 programs at the end of June and who are only allowed to be here for an additional 30 days until about the end of July. The required October 1 or later start date of the H1B petition effectively creates then a gap in the physician's ability to work and remain in the United States. So what is the workaround for this gap? There may be an opportunity to extend an individual's J1 program. The physician should check with their J1 program sponsor and also their school. But we've seen several cases where the only option for a physician was to depart the United States, take an extended vacation at home before coming back to start work on October 1 pursuant to their newly approved H1B cap petition. And this has happened even with a waiver. So unlike F1 students, whom you may be familiar with, who receive H1B cap coverage, which effectively extends their F1 status up until the date the H1B goes into effect, J1 physicians do not have any cap gap coverage. Another timing consideration for the H1B that you need to be aware of is that if someone has been granted a Conrad waiver, they have agreed to start their employment in the HPSA or underserved area within 90 days of the receipt of the waiver. So I think USCIS has been taking the position in many cases that the person must just start as close to that 90-day period as possible once the H1B gets approved and goes into effect. I think it's also important to point out that there are requirements specific to foreign physicians with regard to the H1B category that can have some timing implications. Specifically, to qualify for an H1B visa status as a foreign physician, the physician must have 1, a qualified medical education, 2, English fluency, 3, medical knowledge, and 4, a state license. And I want to talk a little bit more about prongs 3 and 4, the medical knowledge and state license. The third requirement, medical knowledge, is met through passage of all 3 steps of the U.S. Medical Licensing Examination, or USMLE. The physician must have completed all 3 steps within a period of 7 years. So you might have a situation from time to time where you're ready to hire somebody, but they're missing one of these 3 USMLE steps. Well, all 3 steps are required and within a 7-year period unless the physician graduated from a U.S. medical school, is primarily engaged in teaching and research, not clinical practice, or is a physician of national or international renown. A physician might qualify for a USMLE exemption as a physician of national or international renown if, when filing for the H1B, they present evidence similar to evidence that one would submit for an O1 extraordinary ability petition described above. And then finally, a brief note regarding the 4th requirement, licensure. Many state licensing boards will not issue permanent licenses to physicians until they have completed their residency programs. But you may, from time to time, need to file an H1B before the end of the person's residency program, and thus before the full license is issued. You'll want to work with the appropriate state licensing board to see if a temporary license is available prior to the end of June, and if so, submit that temporary license with the H1B filing. In my experience, USCIS has been pretty good about accepting temporary licenses for the purpose of adjudicating physician H1Bs.
Okay, more about H1Bs. You can see how much we love them, but it's like I said, it's key to hiring foreign workers. So what are some other ways to get around the H1B cap? So say you're not a nonprofit, so you're a for-profit clinic, and you therefore can't fall under the cap exemption. You're not hiring a doctor who's already been under a Conrad Waiver program or in an H1B status before, but you really want this position. What are your options? So there's one possibility. It's called a concurrent H1B. And essentially this means that the H1B worker, the physician, has two employers. So they have to work first and have secured a CAP-exempt H1B. So this could be, for example, a physician working at a CAP-exempt hospital that's affiliated with a university, but then they want to also work for a for-profit clinic, or even the clinic may be part of the permission to be studying physicians there, but they're a for-profit and everything's done privately. They can file a concurrent H1B. Essentially, you're piggybacking on the CAP exemption. So what it works is, say you have a CAP exempt petition granted through 2021, the CAP subject petition will file a petition with the Immigration Service and say, we'd like to hire this foreign national, our timing is going to match. Here's proof that the physician is working under a CAP exempt H1B, and we would request a concurrent H1B for the same time period. This is a great way if it can work. And it also provides a means, it could be full-time, it can be part-time, so you have the flexibility in creating those hours. This works well in situations where I call moonlighting. So often we'll all of a sudden get a call from the doctor who's working for his employer but somehow has free time and wants to moonlight and work for a few other clinics on the weekends or pick up extra shifts, but it's not for their H1B petitioner. And so I always have to tell them, you're only permitted to work for your H1B sponsor. They are your only employer. However, if the moonlighting physician wants to sponsor you, they could file a concurrent H1B and allow you to do so part-time. So it's permissible provided they go through the steps of sponsoring the foreign national with a concurrent application. And I have listed below the matter of semio solutions, not because I want to bore you with citations to immigration law, but because this is important for any H1B where workers change work sites. So if you have a physician who is based out of one clinic, but then you have a need because someone went on maternity leave or someone quit and you need to place this physician, the law allows, if it's within the same metropolitan statistical area, you're allowed to post an LCA, add that to the work site, and the physician can begin working. If it's outside of that area, so for example, if you're based in Mankato but you have a need in Minneapolis, that's not the same statistical area. An amended petition would need to be filed prior to the physician or H1B worker accepting that employment. This is essential to follow this rule because it can basically make the doctor fall out of status if they're working at a site that was not notified to the Immigration Service, or if it wasn't properly annotated on your labor condition application. So please keep that in mind, that where the physician is working and where you filed it in the petition is extremely important. One other note I realized I hadn't discussed that could also help you with CAP exemption is a provision called employed at. And this means if you're say for example, you're a for-profit employer, but the physician is going to be working, say 95% at a CAP exempt employer, for example, at a CAP exempt hospital, but you're paying the salary of the physician, you're controlling their work, you could attempt a CAP exempt petition by showing that the physician is employed at a qualifying institution, and we have to show that the majority of their work is at the qualifying institution and it fulfills the fundamental purpose of the CAP exemption. So this employed at is useful, but it actually must relate to the CAP exemption. So this would be limited most likely to your healthcare practitioners and what counted, but that's also an important avenue to look at when you're looking at where they work. I'd like to move on a bit away from physicians and into other type of healthcare professionals. So nurses, obviously a huge shortage and in high demand, but unfortunately the H1B program is extremely difficult to get for nurses. And that's because there's very few nurse positions that require a 4-year bachelor's degree. So in that case, it works well for anesthesiology specialists or maybe nurse managers, but it's been quite limited. So what most people do is they go right to a green card. And that's because the Department of Labor has already designated nurses as a shortage occupation for all of America. Everywhere in the country, they need nurses. And so they've published what's called the Schedule A, which says as an employer, you don't need to recruit and show us you can't find nurses. We already agree how hard it is to find them. So you can immediately file an I-140 immigrant visa petition to sponsor the foreign nurse to get a green card. Now, most likely this would be what we call a third preference category. And for many years, this had a huge backlog, so it wasn't worthwhile. At present, it is current, which means you could get someone who's abroad on a green card over here through this process in as quick as a year. Doesn't sound quick, but that's quick these days under immigration. And so that's an avenue many are pursuing in order to alleviate the shortage of nurses. Another option are for nurses who come from certain countries. So RNs, for example, if they're Canadian, they can come under a TN, which is under NAFTA. Australians could qualify for E3, and then Chile and Singapore H1B ones. However, you have to keep in mind they have special licensing and exams. So nurses will have to take the NCLEX exam and obtain a visa screen prior to being admitted into the United States or changing status to obtain their green card, or if it's a specialist in H1B. This is a set requirement. They're also going to need to qualify for licensure in the state that they'll be working in.
So let's turn now to physical therapists and medical technologists. Unlike your non-specialty nurses, these two professions are viewed as H1B eligible, depending on the employer's requirements, of course, and both are listed in NAFTA as eligible for TN classification. When filing under these categories, again, employers have to pay attention to licensing requirements in the area where the job is housed, as USCIS will want to see copies of licenses for the duration of employment. If it's helpful, if a bachelor's degree requirement is a part of the state licensing requirements, you might have to do a little bit more work in terms of documenting the employer's normal practice of requiring a bachelor's degree if the bachelor's degree is not a part of normal licensing requirements. Also, you need to make sure that employees obtain and maintain for the duration of their stay in the United States valid visa screen certificates for healthcare providers, as there is a screening element for these types of occupations. The visa screen certificate, which Deborah mentioned as well, is from the CGFNS, and that's what typically individuals would present in order to meet that screening requirement. Regarding permanent residency paths for these two occupations, like nurses, physical therapists are also eligible to file for a green card using the fast-track Schedule A process. Medical technologists, on the other hand, will typically go through the traditional three-step permanent residency process that we'll talk about in a bit, beginning with labor certification and then moving on to the preparation and filing of an immigrant visa petition and then an adjustment of status application.
Good. And these occupations listed are all going to require separate licensure, and these are going to be the credentialing agencies. The certificate is good for 5 years, but if you're hiring a foreign national or sponsoring in any of those occupations, you need to make sure that they've qualified for the correct exam and passage for certification before you're able to do so. Moving on to green card options. And so when you've hired a foreign national and it's working out well, you're gonna figure out how to keep them for the long term. The H1B visa that we discussed has a 6-year limitation. The O1 can be extended without limitation. However, it becomes only 1-year extensions and become very costly and nerve-wracking because there's always a risk of a denial even after many years of a claim. All of a sudden you get an examiner who uses their own discretion to make an opposite opinion. So what are some options? I've listed in front of you the National Interest Waiver and Physician National Interest Waiver. What's unique about these is these are self-petition. So your physician can request your sponsorship, or they can actually do this on their own, which there's really 2 different avenues that you're looking at. The National Interest Waiver, it's focused on the physician and how the work they've accomplished and will be doing will benefit the U.S. national interest. Normally, this is less for clinical work and a greater focus is on research. So if they're working on research in the medical field, it's pretty much assumed it's going to have a national impact and be national in scope. That's rarely the issue. The issue is on how is the physician contributing in a greater way where you don't need to use a labor certification requirement. For example, are they working on a critical funded research program, maybe by the National Institute of Health, where the government's already deemed this an important research endeavor because it's giving it taxpayer dollars to fund? Likely that would be a successful national interest waiver because you don't need to look for any other supporting or qualifying physician because this doctor is the one who's providing the top research. In the clinical arena, you'd be looking at what's called the Physician National Interest Waiver. And this is useful because it's for purely clinical care. However, it must be in a HPSA designated area. So essentially, if you have a physician who's working in a HPSA doing clinical work in primary care for a 5-year period, they can get a green card. What's also unique about this is they can file for their I-140 and adjustment of status prior to reaching that 5 years. That's a huge benefit for married couples because you can provide a work authorization to the spouse, and that's a huge bonus. However, I always have to warn, it's still what we call an EB2 preference category. And many individuals don't understand that you can't file your adjustment of status unless your category is still current. So it's not a benefit to certain nationals subject to really long waits, for example, from India or from China, but for other countries who aren't subject to these tremendous backlogs, it's a huge bonus. So essentially, you'd be looking at those who are involved in research and are working on important projects that benefit the U.S. They would go to the national interest waiver. Individuals involved in clinical care, as long as it's primary care and in a HPSA, could look at the Physician National Interest Waiver.
Let's turn now to the extraordinary ability category. This is another one where the physician or healthcare provider could apply on his or her own without the need for an employer sponsor. It's not unlike the H1B visa that we talked about earlier. In fact, the criteria for the category is almost exactly the same. I will say that USCIS does tend to judge these cases a little bit more harshly and subjectively, and the approval rate is much lower than in the H1 category. Nevertheless, it's a good option for some, especially those who are operating at the very top of their field of endeavor. Turning now to the PERM labor certification process, this is the far more common path to permanent residency for healthcare providers and others alike. This is the one that majority of workers are going to have to go through, and it involves the traditional 3-step permanent residency process. So labor certification is the first of the 3 steps in the traditional 3-step process, and it essentially requires the employer to demonstrate to the Department of Labor that there are no qualified, willing, able, or available U.S. workers to fill the permanent position the employer wants the foreign worker to fill. The process involves a market test where the employer has to undergo strict recruitment steps. They have to review candidates to the job and verify that the candidates to the job do not meet the minimum qualifications for the role. If they identify any qualified U.S. workers, it's not that they have to hire those U.S. workers. It's just that in most cases, the labor certification process has to stop at that point and an application cannot be filed unless the employer is able to offer jobs to those U.S. workers. Another potential drawback or barrier to filing the labor certification is if the employer has had layoffs of U.S. workers. Typically, we would not recommend that an employer file labor certification within 6 months of a layoff. If the employer does need to file within that 6-month mark, they have to be able to demonstrate to the Department of Labor that they have proactively reached out to laid off workers who held positions that fall within the same or similar job within the area of intended employment as the foreign worker. If you get through the labor certification process, you get through the recruitment, you get through the vetting of candidates, and you're able to file the application with the Department of Labor, employers are always subject to the possibility of an audit by DOL, in which case the employer has to turn around its recruitment materials and the resumes of candidates to the job to, convince the Department of Labor that it's done what it needs to do to make sure that it's first and foremost, offering jobs to U.S. workers. If the labor certification application is approved, then the employer gets to move on to the next steps in the process, the preparation and filing of the immigrant visa petition or I-140 petition. And once an immigrant visa is available to the foreign worker in his or her preference category, the filing and preparation of an adjustment of status application through Form I-485 with USCIS.
And finally, I'll talk about outstanding researchers, which also includes outstanding professors. This is an EB1 category, which means it's first preference. And this is essentially a lower level than the extraordinary ability category. By regulations, essentially the applicant needs to establish 2 out of 6 categories. And most, I think, physicians or high-level professionals could meet at least 2 categories. For example, that they've received a national award or they have publications or original research or work. However, the harder part about it is what I call the totality argument. So what happens is the Immigration Service will state, just because you've established that you have documentary evidence in at least 2 categories, how have you proven that your work is considered outstanding next to others in your field? And so part of this is working to define what is their field of specialization. For example, if you just said you're a surgeon, that's an extremely broad category. So then we'd narrow it down and say, what kind of surgeon? Oh, you're a pediatric surgeon. And then narrow it down from there. And if you go to the heart of the specialization, you're likely going to show a much higher level of acclaim and having national renown within that particular field. So you want to look at what is the field that the researcher or professor is actually outstanding in. And then, so then you have what we call, the fact evidence, copies of their publications, copies of their offer of employment. So this outstanding researcher or professor petition needs to be sponsored by an employer. This cannot be done independently. You would control the application as an employer to pursue this on their behalf. So you have to have an offer of employment. If you are in a professor, you must actually be in tenure track. Or if you're a researcher, for example, you need to show that you have a long-term funding for your project. So even though I know in many university appointments they may be annually renewable, if you can show long-term funding, you can still use this research category. I would say in terms of for outstanding individuals, this is likely the category that we would lean to first if they have an employer sponsor, because the standard of adjudication is just a bit lower and more successful than the extraordinary ability petition. And it's useful by showing it's fast track for the most part because it's first preference. So oddly enough, for the first time in I'd say 20 years, first preference is backlogged and second preference is available. And what this means is that someone who's extraordinary or outstanding is going to take longer to get a green card than potentially someone going through the PERM process that Jenny just discussed, or who file a national interest waiver. So it's an extremely strange time right now. And overall in immigration, I would say it's also a strange time, but a much more delicate time for foreign nationals. Just because the standard of review by the Immigration Service has gone up in nearly every category, making even the most basic petition much harder to get approved than in any year past, which increases the anxiety level of your employees and the foreign nationals and their family. And so having a strategy at the front end from hiring the individual up until the end of securing their green card and eventually U.S. citizenship is important to maintain their level that they can focus on their work for you and not the anxiety and worry they may have living in the U.S. at today's age. So we greatly appreciate you joining us today. We have saved time to take questions. Again, you can hover over the chat feature and we will be happy to answer them as they come in. Or you may feel free to reach out to either of us within our group and we'll be happy to answer your specific questions privately. And I did receive one question so far, so I'll be happy to answer it. And the question asks, can for-profit clinics qualify under the university affiliation? And unfortunately, the answer is no. The regulations set out that it must be a nonprofit. However, this could be a case where potentially they may want to look at the concurrent H1B filing or the employed at provision to see if there's any basis to sneak in under that exemption. All right, well, we thank you very much for your time and welcome your contact in the future, and have a great afternoon.